Hello there.
Lórí Facebook, lórí YouTube.
Good morning to you. Good afternoon to you. And good evening to you from wherever you are joining us. It is brunch time with Mayegun live. Please read the caption of the broadcast, like it, share it, invite your friends, invite your not so friendly friends, and tell them that Mayegun is live. If you have been following the media, for example, if you are already awake like us right here in Europe, Nigeria, possibly have heard that the action of Boko Haram's regime in 2021, when they connived with the Kenyan authority to kidnap Nnamdi Kanu, has backfired again. It has.
Lórí Facebook.
A Kenyan High Court just ruled, and that is 3 days ago, that the abduction of Mazi, Nnamdi Kanu, the leader of the indigenous people of Biafra, IPOB, his abduction in 2021, June, by Malamu, the Attorney General to Boko Haram at the time. They committed an international crime, something that if people actually take it up with them, Nigeria should be sanctioned for such acts. It is all in an effort to have Nnamdi Kanu in their custody, like a trophy. Not because he did anything wrong. They sold a lie to the security and the government of Kenya. They said Nnamdi Kanu was meeting terrorists in Kenya. And when they found out that he wasn't, rather than let him go, they decided to hand him over to Nigerian agent with a private jet, and then a syringe in hand, drugged Nnamdi Kanu and bundled him straight to Nigeria for a crime that doesn't exist. So even in Nigeria, in their own court, he already has a judgment against them, which is over $1 billion on the abuse of violation of his fundamental human rights. Mazi Nnamdi Kanu, that you can call a cat with 9 lives, the bone that is tied around the neck of a bully dog. So the copy of that judgment, 64-page judgment from the Kenyan court that condemned that action of the Kenyan security agents, the government, and Nigeria. We have that copy on Mayegun's diary political this morning or this afternoon, depends on the time you are watching. Now, you know something about brunch time with Mayegun is that you can actually call in anytime. Also, after sharing the broadcast, right, you can listen to it like you are listening to a radio podcast, because it is the content of the judgment that we are going to read on this program today, and we are going to do it together. So if you have shared the broadcast, thank you. What today? So, good morning to you once again, and welcome to the brunch time with Mayegun. Please give me a sec. I need to write. Just a moment, please. So we have a copy of, Mazi Nnamdi Kanu's case against the government of Kenya and the authorities there that worked with the Boko Haram's government to kidnap him in 2021. Now, this case is specially instituted against them in their own court in Kenya. So it is from the Kenya High Court. A copy is currently public. Anyone who has a link, currently my hands are busy. So anyone who probably have the link should please share it in the comments, I would say. So we have a copy that if it was like individual versus individual, it would have been a case of criminal abduction. And that in itself, if found guilty, should guarantee a life imprisonment for such a perpetrator. But the plot to kidnap Nnamdi Kanu was between two countries, two presidents. And when I say two countries, that means two governments of two countries. Uhuru Kenyatta of Kenya, as well as Boko Haram of Nigeria. So it was at the time that Mazi Nnamdi Kanu, the leader of the IPOB, was demanding for a peaceful referendum to determine if the people of Biafra, the eastern part of Nigeria, they still want to continue to be part of Nigeria or not. Now, conspiracy thickens as interest, or vested interest started showing, their interest and plot to not only crush that advocacy, right, but to indeed kill the leader. That is Mazi Nnamdi Kanu. Now, they've spent a lot, not only in Kenya, across Africa, where they have collaborated with some of the despots, the dictators of Africa, to keep tracking him. So Kenya pretended to be lucky, in which we are not going to go into what they were given in exchange. But what did Kenya court, after listening to all parties, what did the Kenya court say in their ruling? So I'm going to ask you to please sit back, relax, and maybe we should. So right on your screen, sorry, brethren, one sec. So right on your screen is the copy of, the court ruling. This is from Kenya, or Kenya High Court. Right, I am going to skip okay, let's start from the first page, okay? So I'm going to skip and get to the point where the judge read out, his ruling. So here, Republic of Kenya, in the High Court of Kenya at Nairobi, Milimani Law Courts, Constitutional and Human Rights Division, Constitutional Petition number E359 of 2021. Kingsley Kanu, suing on behalf of and representing the subject, Nwanekai Nevi Nnamdi Kene Uku Kanu, as the petitioner, versus Cabinet Secretary, Ministry of Interior and Coordination of National Government, first respondent, Director of Immigration Services, second respondent, Director of Criminal Investigations, third respondent, Officer Commanding Police Division, Jomo Kenyatta International Airport, fourth respondent. So these are the people sued by Mazi Nnamdi Kanu then the Attorney General, 5th respondent. Now, I am going to, like I said, I'm going to read this judgment while you sit back and, like I said, observe. At a point, we shall open the line. Get what I mean now? So at a point, we'll open the line, and let me frame my screen in such a way that will be easier for all of us. You get? Bear with me 1 sec. I'll take off the comment for now. Okay, we'll come back to that. 1 moment. No, that's too like wide. Okay, let's get something else. I want to make sure that the center of your reading is the judgment on your screen. Do you get that now? So I can, my voice can come from the background. So just before I continue, because there's something about this. Normally, you have to put on your headset so that I can hear what's going on. So that's why I do ask people, since I don't do that, so I ask people to let me know if my voice and the audio is perfect before we get so fully into it. Because the next, I think, maybe the next half an hour, I am going to be reading through the judgment that Kenya High Court just delivered, against the Kenyan authority, and of course Nigeria too. But it is not just that judgment. If you want to remind, if you want to be reminded rather, you will know that even the ECOWAS court, Mazi, Nnamdi Kanu, has won Nigeria there, not once, not twice, 3 times. IPOB as part of the judgment against Nigeria, still on this matter. Okay, so thank you. If you can hear me loud and clear, then we are sorted. So let's get on with it. So the judgment, introduction. This is like the judge, what the judge delivered. It is a 64-page judgment. So so the introduction, anyway. So the first one, so introduction 1. Kingsley Kanu, the petitioner, filed this petition on behalf of his brother, Mr. Nwaneka Envy Nnamdi Kenny Uku Kanu, to be referred to as Mr. Nnamdi Kanu, for violation of his rights and fundamental freedoms. He sought declarations of violation of the rights and order compelling the respondent to provide information regarding the arrest, detention, and rendition of the Mr. Nnamdi Kanu from Kenya, and an order for compensation. The petition is supported by 2 affidavits, one by the petitioner and another by Prince Emmanuel Kanu, Prince Kanu, another brother to Nnamdi Kanu, and written submissions. The petitioner's case. The petitioner stated that Mr. Nnamdi Kanu, the leader of a Biafra group calling for self-determination for Biafra land, is a British citizen who formerly held Nigerian citizenship, but renounced the Nigerian citizenship, and his Nigerian passport was taken away by the Nigerian authorities. On the 14th October 2015, Mr. Nnamdi Kanu was charged with terrorism-related offenses and incitement and detained for 2 years, but was released on bail in 2017 following an attack by the military of the federal government of Nigeria that killed several members of the Biafra party. Mr. Nnamdi Kanu fled into exile. On 12 May 2021, Mr. Nnamdi Kanu flew to Kenya from Kigali, Rwanda, and arrived at Jomo Kenyatta International Airport on an East African tourist visa and stayed at Purple A's apartments, Kitale Lane, Nairobi, intending to spend a few days in the country before traveling to the United Kingdom. On the 13th of May, 2021, Mr. Nnamdi Kanu was admitted at Nairobi Hospital due to a heart condition and was discharged on 14th May 2021. On 19th June 2021, he drove to Jomo Kenyatta International Airport to pick someone, but did not return to the place he was staying. This information was relayed to the petitioner by Mr. Nnamdi Kanu's secretary, Ms. Erina Notana Gitao, who also confirmed that Mr. Nnamdi Kanu's passport was still at the place he was staying. According to the petitioner, on 29th June 2021, the Attorney General of the Federal Republic of Nigeria addressed a press conference revealing that Mr. Nnamdi Kanu had been extradited to Nigeria. Cooperation between Nigerian intelligence services and Interpol. 7. Just a quick one, just for the record. In the course of this shameless, brazen abuse of power by Boko Haram and Nigeria, in continuation Tifnumbu, Interpol had come out to say they had nothing to do with the arrest or the abduction, as well as the extraordinary rendition of Nnamdi Kanu to Nigeria. Just for clarity. So this Interpol being mentioned here is because Mr. Malamu, the Attorney General in Nigeria at the time, who broadcasted Nnamdi Kanu's abduction in Hausa language for the Hausa audience in northern Nigeria, said Interpol helped them. But no, Interpol said, no, we're not involved. No, they've already told court. Just for reference or for the record. But let's continue. The petitioner's case is that Mr. Nnamdi Kanu was taken to Nigeria contrary to the procedure set out in the Extradition, Contiguous and Foreign Countries Act. He was not shown a warrant of arrest, was not allowed to speak to his legal counsel, intermediary or family member. Mr. Nnamdi Kanu was also not allowed to challenge the lawfulness of his detention and subsequent removal from Kenya, and had never been classified as a prohibited immigrant in Kenya. The petitioner asserted that there were concerns that Mr. Nnamdi Kanu was being tortured while in detention in Nigeria, given the history of being tortured by the Nigerian authorities, thus putting his life in danger. The petitioner asserted that Mr. Nnamdi Kanu's arrest, detention, and removal from Kenya was done in violation of the Constitution of Kenya, the Fair Administrative Action Act 2015, the Extradition, Contiguous and Foreign Countries Act, and the Public Officers Ethics Act 2003. Prince Emmanuel Kanu, Prince Kanu, swore an affidavit stating that he had been authorized by Mr. Nnamdi Kanu to swear the affidavit because Mr. Nnamdi Kanu could not swear one since he was in detention and was prohibited from swearing an affidavit. Prince Kanu stated he had met Mr. Nnamdi Kanu on 27th July 2021 at about 3 p.m. at the headquarters of the State Security Services in Abuja, Nigeria, and he believed the facts given to him by Mr. Nnamdi Kanu to be true. Prince Kanu deposed that on 12 May 2021, Mr. Nnamdi Kanu entered Kenya legally as a British citizen and settled at a temporary location in Nairobi. On 19th June 2021, Mr. Nnamdi Kanu drove to Jomo Kenyatta International Airport on a personal errand. As soon as he parked the vehicle and alighted, several agents of the Nigerian government accosted and abducted him, handcuffed him, bundled him into a vehicle, and sped away. The abductors took Mr. Nnamdi Kanu to a house within Nairobi and chained him. They did not show him an arrest warrant issued by a court in Kenya or an extradition order.